Welcome to Legal Dilemmas, where you will find clear, concise legal advice. My name is Sabina.
And my name is Brenda.
So, Brenda, today I'd like for us to discuss the area of inheritance. Specifically, I'd like it if you could help us understand the Inheritance Provision for Family and Dependents Act 1975. It is a bit of a mouthful, so I'm hoping you're going to be able to explain it in layman's terms for us.
Okay, so in short, it is often called the Inheritance Act 1975. Now, this legislation is designed to provide recourse for individuals who should have benefited from a will, but they didn't, and they are in need of financial help.
Can you give us any examples of situations where this could arise?
Yes, it could be where a divorced husband remarries again. He has children from his first marriage, but then he makes a will and leaves everything to his second spouse and children from the second marriage. So then the children of the first marriage may not get anything, but they do need provision.
That's actually really interesting. And what factors does the court consider when somebody makes a claim?
Okay, first of all, I'll tell you who can make a claim. So it can be the spouse or the former spouse of a deceased, a cohabitee, or a child of the deceased, or anybody treated as a child of the deceased, and finally any other person that was being maintained partially or wholly by the deceased. So the legislation is quite complex, but what the court will consider is the financial needs and resources of the person applying, the needs and resources now and in the future, then the financial needs of any other beneficiary of the estate. They will also look at the size and nature of the estate, and then if there's any disability relevant for the applicant or any other party, conduct, and any other matter. So, I mean, it could be the case that you often hear of these cases that are in the press where there's a multi-million-pound empire and somebody's been left out, so they take it to court to have provision made for them. But they have to show they need it, or that they were being maintained by the deceased partially or wholly.
I actually have got a really good example of that happening, where one of my clients, he made a will, but he didn't mention that he had a former wife, whom he was estranged from, and she was living in Jamaica, but he was sending her regular payments. And on his death, she made a claim under the Inheritance Act 1975 because she said she was being maintained prior to the deceased death. So that was a bit of a turn up for the book. So I suppose it can happen with small as well as big estates.
Well, it can, yes. I mean, I had a case some years ago where a man died. He only had a small house. The house went to his current wife, but he'd been paying maintenance for his daughter from his first marriage. So then they claimed.
So I think really, I suppose the message to the audience is, I mean, practically there's lots of different ways that you could potentially make a claim, but please seek legal advice because the rules aren't straightforward. They are quite complex, and navigating them will not be easy on your own. Obviously, there's no legal aid out there, no public funding, so you would have to pay privately. But hopefully this content has assisted you in some way. Please like, subscribe, share, and keep those notifications on for further great legal content.